Okay. Well, chime in if you need us. We're going to put everybody on the phone on mute, but let Cindy know if you'd like to speak, and we'll unmute so you can ask questions or have comments or anything like that. So, Zach, did you want to start with kind of some slides just to kind of give everybody a little bit of background who might not know? We're going to spend a lot of time on this stuff, but we just want to get a little bit of background so everybody could see kind of the areas that we're talking about and some of the information that's been put together in the Desal committee in case you haven't seen it. So Zach will go ahead and do that, and then we'll kind of start a discussion on what we're here for.
Yeah, sure. So, again, I'm Zach from AWR, and if you've been a part of the Desalination Committee from start until the current day, then you probably are familiar with what we're about to go over, but just a quick background of where we've come from. So, with the Brackish Groundwater Inventory for Arizona report from Montgomery & Associates back in 2008, this was a map from USGS kind of depicting some of the areas where there's high TDS levels, so areas that could be potential sites for a brackish desalination project. And they were ranked on this list here by the contractor, Montgomery & Associates, so that we have top 6 there that we honed in on as a committee and just did a deep dive on whether or not these areas were feasible for desalination purposes. And when Bob Lotz was the committee chair of the Desalination Committee, there was a table that we created that did that deep dive on each one of those 6 areas. And what you have in front of you at the table there is that spreadsheet that takes a look at all these different categories, from sustainability of supply all the way out to regulatory legal issues. And that last column there will be what we focus on for this committee until we decide otherwise. Thank you.
Okay. Thanks, Zach. So what I thought we would do is we would build off the work that the Desal committee has done identifying these sites, and they've narrowed them down to these 6 or 7 sites. And our charge at this committee is to look at the regulatory and legal issues of that. If everybody remembers a few meetings ago at the Desal committee, Philip Richards, the chair, there was a large discussion around the Buckeye waterlogged area and the Buckeye area and some of the issues that were coming up with that. And there was a lot of discussion about it. And so he created this subcommittee to focus on regulatory issues. What he wants us to look at are the regulatory and legal issues of desalination, not only in the Buckeye waterlogged area, the Buckeye West Valley area, but in all these areas that were identified originally in the Desal committee. So because there's been a lot of work already done with that, I thought what we could do is start with that spreadsheet that Zach has up and look at that, because one of the categories that they have is for regulatory and legal issues, and we might be able to use that as a starter to go through this and identify some of those things. And you know, this sheet is very comprehensive. It's got a lot of different things about the brine disposal challenges and some costs and local issues that might come up and things like that. But what we're charged with is looking at regulatory and legal issues. And so what I thought we could do, if there's anybody else that has any opinion about it, what we could do is start with this list and start looking at different areas about some of the legal challenges that might occur in those areas. So nobody else has any problems. Can everybody see? I know in the back it might be able not to see very well, but you got some screens back there, I guess. But everybody should have a handout with this sheet, and we can kind of build off of that. Basically, when I was talking with Philip about it, he wants us to put together a comprehensive list of the legal hurdles or regulatory hurdles that are involved with desalination, because at the end of the day, that's one of the challenges that we're going to have with this process. So unless there's any questions, I don't know, other than just diving right in and just start talking about some of these things. And maybe what we could do, instead of maybe instead of just going down the list, we have a large contingency of the West Valley here, not only with Buckeye but Goodyear's here, and CAP and SRP and So maybe we could start with focusing on that area, because a lot of the regulatory and legal issues that are involved in the West Valley area are going to be associated with some of these other areas, especially because of the AMA and the management plans and the statutes and rules that are included in the active management areas. They may or may not apply to other places, but I thought maybe we could start there and go through some of the regulatory hurdles that you see might occur in those areas. So this is really small. I'm having a hard time reading this. So now, I'm just making this real informal. So when anybody has anything they want to talk about or say, just pipe up and let me know, because really what I just want to do is be able to put together this list for Philip and get this process rolling. I don't see us meeting about this multiple times and spending a lot of our time with this, since a lot of work's already been done. In the West Salt River Valley, it's inside the AMA, so there are a lot of regulatory, they're not issues, they're just requirements that are involved in something like this, because at the end of the day, this is still groundwater. What we're talking about is Brackish groundwater, and according to the statutes, it's groundwater in the Groundwater Management Act, and so we have to treat it as such. Now, the waterlogging condition, in my mind, it benefits the farmers. It's for the farmers to excuse them of their water duties for withdrawal fees and things like that. So the waterlogging designation has a lot to do with your irrigation grandfather rights and the exemptions that go along with that. But as far as pumping groundwater in this area for municipal or industrial use, it's groundwater, and so it's associated with all the rules and regulations that come along with pumping groundwater anywhere in the AMAs. And so some of the regulatory hurdles and issues that we have in those areas are, you have to have an authority to pump groundwater in this area. You have to have, if you're going to utilize wells, are they pre or post code wells? And if you're going to drill brand new wells, are you impacting surrounding land or water users in the area? Pumping the water, you may have a management plan criteria that you have to meet depending on the end use. There's annual reporting that needs to be done. There are transportation statutes. I was reading through some of the transportation statutes this morning, and there's a number of items that you have to do in order to transport groundwater across basins. Inside the AMA, it's fairly straightforward, but some of these other areas, like if you look at Yuma, there's a lot of regulatory issues with obtaining a permit to pump brackish groundwater in the Yuma Basin and bringing it out of that basin and potentially into an active management area. So there are a number of things that you have to do with that as well. So starting with the waterlogged area, those are kind of the top regulatory items that I kind of thought of just kind of looking through this that will maybe need to be a part of this overall comprehensive list for the Desal committee to consider when they're looking at different areas and things like that. Some of the things that are included in this column, is the uncertainty of the duration of the designation of the water, and can DWR reconsider the duration of the water logging determination? And that kind of goes back to the legal aspect of the water logging condition in the first place that I talked about, that it's really associated with the irrigation grandfathered rights. And so it's an issue that we can list, but when it comes to pumping groundwater for desalination purposes and perhaps municipal or industrial uses, the waterlogging exemption, unless I'm wrong, really has no bearing on anything like that. It really mostly has to do with the grandfather rights.
I'll turn on the mic. I'll speak to some of these issues.
Sorry, Mark. I hate to interrupt you, but I needed to tell everyone that before you speak, just for the folks on the phone and for the recording, if you could state your name and who you're with before you start talking. So, and I don't think I actually did that before I started talking.
Well, I certainly didn't. My name is Mike Pierce, and I'm an attorney. I'm here representing Buckeye Water Conservation and Drainage District. And we've been thinking about these issues quite a bit lately, and I think I would like to start with the proposition that the district was formed 100 years ago in reliance on the flows of the Gila River and surface water diversions out of the Gila River to the farmlands, and many of those lands have been there for the duration of all of that. As the Salt River Valley system advanced and dams were constructed on the Salt River, the flows were reduced, and particularly over the many decades, the urbanization of the valley as a whole has reduced the flow of the Gila River. But we believe, and we think it's borne out by the modeling work that ADWR is doing on the water logging, that there's still a significant underflow of water coming down the alluvial aquifer of the Gila River through the waterlogged area, and in fact is the principal cause of the water logging. When the Groundwater Act was passed, I mentioned one more thing previous to that. There was a court case in the early 1900s called Benson versus Allison that resulted in a decree of the water rights in the West Salt River Valley, and those rights were decreed by priority date and their precise location, point of diversion, point of delivery, and the water duty for those lands was modified somewhat as the decree evolved, but it ends up to be about 9 acre-feet per acre surface water. And that's a rather extraordinary thing in Arizona, but it's merited in the Benson-Allison decree area because of the nature of the lands and the soils and the salts. And the idea for a century has been to apply more water than is needed for the evapotranspiration of the plants to flush through and allow the crops to grow without having their salt tolerance exceeded. And yet at the same time that contributes to water logging and invasion of groundwater into the root zone. So that water has to be removed in order to have effective farming. When the 1980 Groundwater Management Act was passed, everyone in the active management areas applied for irrigation grandfathered groundwater rights because that was the thing to do. It would have been foolish to do anything other than that, even if you had well-perfected and well-established surface water rights. So everyone in the Buckeye Water Conservation and Drainage District has an irrigation grandfathered right and is therefore allowed to apply groundwater to their lands. Then, as we all know, through the 80s and 90s, the debate escalated over what exactly was groundwater versus surface water. And in Buckeye's particular situation, the need to pump more groundwater, if you wanted to call it groundwater, was needed because they couldn't continue operations the way they had been operating if they were limited to 4.5 or 5 acre-feet per acre. So the water logging exemption was created, and we've been operating under that for many years. And I think it's fair to say that there's still uncertainty as to what the nature of water beneath the surface of the earth is in the alluvial aquifer, or the saturated floodplain Holocene alluvium, if you want to call it that. But there's clearly evidence emerging in the San Pedro watershed that the water found immediately adjacent to and beneath the stream bed is going to be classified someday as surface water. And we, of course, believe that it already should be classified as surface water. Yet at the same time, we acknowledge and understand that there's this overlay of groundwater law right on top of the same water resource. And it makes a huge difference whether you start your inquiry by looking at the resource and calling it groundwater or surface water. Completely different laws apply, and they don't interact very well together. Under groundwater law, you can do certain things. For example, you can apply for and receive a poor quality groundwater withdrawal permit to remove water that is defined as water that, because of its quality, cannot be put to beneficial use without treatment. And if you can meet that standard, you can withdraw that groundwater and use it for beneficial use anywhere in the active management area. That law exists today as a remnant of the original 1980 Groundwater Management Act, and it's been deployed in places around the state. But in our case, the opportunity to withdraw water under that kind of a permit puts another layer of groundwater withdrawal authority into the basin that presents the opportunity, as this committee and its predecessors and many others have seen, to take the water out that is at a very high level, very short distance below land surface in that area, and put it to some kind of a use as poor quality groundwater. Scott is well aware that there is a pending matter that addresses those issues that is not quite yet finished, and I'm not here to argue the merits of it one way or the other. I respect the positions of the parties on it, but I will say this: the existence of that statute to us is a significant threat to our continued ability to farm in the way that this land has been farmed over the last 100 years. And I would put that into the category of impacts, local impacts, third-party impacts. I don't know what name you'd like to use, but in your local issues on this, it does address it. It says surface waters could be negatively impacted by redirecting existing drainage pumping. That's only part of the equation, but it's there. And more importantly, and this is the bottom line for the district, because of the need to withdraw due to the reduced surface flows, water from beneath the surface of the earth by electrically operated pumps in larger quantities than most agricultural fields within the state, it costs a certain amount of money to farm. If those water levels drop significantly, those wells have to be deepened because most of them are quite shallow, and the cost per acre foot increases significantly. So the ability to farm at the current economic level is directly related to the level of water in the waterlogged area. I was interested to see the preliminary results of the DWR model that showed very little change anticipated in the waterlogged area. We perceive that as very good news, even with some impacts being associated, increased withdrawals. But what we would like to see is a recognition by this committee, or if not, by someone, that water has a component of a property right to the farmers, being surface water. It's not a common resource that should just be construed or regarded as being available for anybody that would be willing to come in and remove it and sell it at a profit or utilize it for their own economic benefit. And that's really the reason we're here in force today, is to make that point. I think you all understand it well enough, but I think it needs, to be stated on the record. But that's where we start. And let me just summarize real quickly what we think should be addressed, and that is, does the brackishness of this water under state law currently mean that it is available for exploitation by anybody that would want to take it? And if that is true, and I'm not entirely sure that it is, but if that is true, is that a proper regulatory safeguard for those that would be negatively impacted by that existing state law? Secondly, to come in and start withdrawing large quantities of water from this area, particularly from wells that are located within or immediately near the saturated floodplain Holocene alluvium. We think that that is a speculative investment on the notion that that water will always be characterized as groundwater. And we have been considering and will continue to consider ways to bring that issue to the forefront in appropriate forums and make that case. But it does impact the economic viability of someone who would construct a large-scale operation thinking that they could exploit this resource under groundwater law without limitation of surface water law. So those are our two big points. Like I said, I'm sure you all understand it, but that's kind of what we came here today to say, I think.
Thanks, Mike. I really appreciate those comments, and I think those comments were discussed at the desal committee level, and that's what created this committee, is the concerns that you folks had in the West Valley and some of those things that you talked about. So I really appreciate those, and I know that Philip and the others on the committee understand that and want to make sure that we talk about that and we recognize that in this process. So I appreciate the comments. That kind of leads along with Gretchen. Gretchen and I were talking earlier about another issue that she wanted to talk about. So if you want to kind of build off of what Mike just said.
Gretchen Irwin, City of Goodyear. Actually, I do have something to add to Mike's discussion, and that I believe there is something in statute that says that water cannot be transferred between sub-basins. It can, but somebody in the basin that it was withdrawn from can claim that they've caused harm by transferring it out.
Yeah, it's subject to payment of damages, and
right.
There's a statute that talks about what that means and everything else. So you're right. Yeah, there are transportation statutes that talk about where you can transport the water and things like that, and what's associated with those payment of damages or who are subject to payment of damages. So yeah, I understand. So that's another good point.
Right. I don't know if where the target withdrawal area is or where the target use area is, if it's in the Hacienda or in the West SRV, but Goodyear would still like the water to stay where it is. So the other thing that I talked to Scott about earlier is the assured water supply issues that are ongoing right now. If water is withdrawn in any large quantity, probably from anywhere in the AMA, not just the Buckeye Waterlogged area, it's going to impact somebody else's physical availability. And so I think that's a part of the discussion that needs to be made. Anybody withdrawing water either in this AMA or Pinal AMA in excess of what is currently used, because whatever's currently used is already considered as in the assured water supply modeling. So I think that's another thing that needs to be addressed. I also want to agree with Mike on the fact that the water is poor quality groundwater. However, does that mean it has less value than potable water? I think we're at a point in the state where all water has value, and to target this water as having less value or that it's available to someone else is not a good path forward. We need to be looking at effluent and poor quality groundwater and potable water if we're going to achieve our goals. So everything, it's all about sustainability. It's not about what community can we take water from. So that's all I have to say. Thank you.
No, thank you very much. Again, we talked about that before the meeting, and I appreciate those comments because that really does have ties into the assured water supply program. You're absolutely right. I mean, part of the requirements of an assured water supply determination is physical availability, and increased pumping in any area will cause the models to change and things like that. So it's definitely part of this process that we have to think about. not only not legal availability of the water and regulatory issues, but also how that ties into it, and physical availability ties right into it with the Assured Water Supply Program. So I appreciate that comment. The other thing I kind of wanted to throw out that was mentioned in this spreadsheet is, and I kind of mentioned it at the beginning, was one of the regulatory hurdles is, at the end of the day, this is groundwater. Right now, Mike, I understand, at some point in time, there's going to be a determination made in this area of what's surface water and what's groundwater, and how we're going to have to deal with that. And it's clear on the Benson decree that you talked about, that's in place, and that's something that we're going to have to deal with down the road. Today, permits are issued all the time with the idea that we're dealing with groundwater right now. However, if it's ever a decision of the court that it's become surface water, then things may change and all of that. So I have to just kind of look at what we know today and what we're dealing with today. And at the end of the day, at the end of today, this is groundwater. And so the idea that groundwater in these brackish areas are treated as groundwater. One of the items that were brought up in this previous committee that looked at this, that put this together, said, will ADWR consider brackish groundwater treated through desal in an alternative manner under state law? Is this you don't want to call it a fourth bucket of water, but will it be treated as differently? It's not just groundwater, but it's brackish groundwater that can be used in a different way. So I didn't know if anybody had any comments about that. When I read that, I thought, well, that's always something that a lot of folks talked about was, is this groundwater, is it surface water? But if it's groundwater, should it be treated the same as other groundwaters in other areas? If you're in the waterlogged area, you can't get a recharge permit to recharge your effluent because of the waterlogging conditions. And so there's just all kinds of different things that go along with that, and should this water be treated differently. So I just wanted to throw something out like that, because it is on our list of issues that we need to consider, and is that something that we want to talk more about? I didn't know if anybody had any comment about that.
Scott, so are you saying that possibly if someone pumps out 100 acre feet and they have to desal or RO the water, they only recover 80 acre feet, that the full 100 acre feet would not have to be replenished? Only the portion used? Or, is that where...
It's an idea. All I'm doing is throwing out the idea that, should this, if it's classified as groundwater, if it's classified as brackish groundwater, should it be treated the same as groundwater that's of better quality? I'm just throwing out the idea because they posed it in this aspect, that could this somehow be regulated differently? For example, there are provisions in the Assured Water Supply rules that allow for, if you're in the waterlogged area, for relief of replenishment obligations for that. It's very vague on how it's used, and because the Assured Water Supply is based on a 100-year determination, and the waterlogging conditions are only really identified by the state for 20 years, something like that, the Assured Water Supply Program can't just say, well, every drop that you pump in the waterlogged area doesn't have to be replenished, because it's not a 100-year supply. It's only been designated for the next 20 years as being waterlogged. And so it's not very helpful in my mind, but it's there. It kind of identifies that if you're in this area, maybe that water can be exempted from other things. I think, is it the management plan? I'm sorry, I'm reaching back now, but I think in the management plan, don't you get a break if you're a golf course pumping groundwater in the waterlogged area, and something will have to do with your management plan requirements? So we don't have to get into the details about that, but I thought there was something like that. So it's just kind of this idea that, this water is groundwater, but it may be exempt from certain requirements that maybe better quality water is treated.
This is Natalie Mast. I am not familiar with an exemption for golf courses in the waterlogged area. I think what you might be thinking of is the kind of bonus water that they get associated with using effluent. Okay. So there is a calculation associated with effluent for golf courses, but I'm not familiar with anything related to the waterlogged area.
Okay. So that's all I was really just throwing out there, because it was mentioned in here, and it's another idea that, you know, if the committee moved forward and they wanted to make recommendations, that might be one of the recommendations. But I just wanted to get input from everybody on that. So Mike, if you have something about
Mike Pierce again. One of the reasons for looking at brackish groundwater is to find a source of supply that is untapped, so to speak, that can be used to backfill some of the difficulties that are increasing in being able to prove 100-year physical availability. So if you were to take that groundwater out and use it, for example, as a source for CAGRD replenishment, then obviously it makes no sense to withdraw water for replenishment that you then have to replenish. So that, I think, would take a change in law to just effectuate that use of the water. But it could be a good use of the water if that could be treated to potable standards and used to displace some other, through exchange or something like that, to displace something else that could be used for groundwater replenishment by the CAGRD. Secondly, if it were water that could be deployed to shore up a determination of physical availability, let's say in the Hassayampa Basin, for example. Some of the waterlogged areas in the Hassayampa Basin, so I don't even know if it would incur the subject to payment of damages if it were moved, but again, at the cost of treatment and moving it considerable distance, at least somewhat uphill, there has to be a financial incentive to try to do that. And again, that could be addressed through state law to make that easier to do, to move the water where it's needed and deploy it in a way that would be acceptable for assured water supply principles. I think I second Gretchen's motion that physical availability is probably one of the biggest challenges we're going to face in the next decade in the state, at least in the populated areas. And we need to start looking at alternatives to the traditional do a hydrologic study, drill a well, and show 100-year physical availability of groundwater and join the GRD and you're done. That model worked well for a very long time, and it's beginning to sunset. And so we're going to have to look at other ways to meet the statutory, and I've often thought laudable goal of saying that if you buy a new home in Arizona, you have a 100-year water supply that comes with it. But that doesn't mean we can't find new ways to satisfy that type of standard. And this kind of water can be used for that. And really that goes far beyond the West Salt River Valley Basin. But it's probably going to take some thinking outside of the box. I'll look at modifications perhaps to the assured water supply rules or the assured water supply statutes to facilitate some of the use. So that's a regulatory, I don't know if I'd call it an issue, more as an opportunity to look at ways to incentivize the use of water to a higher and better means, knowing that the cost of treatment, as I think is detailed somewhere on this sheet, is by today Arizona standards prohibitively expensive. So if we're going to use brackish water as a resource, we need to find a way to make it economically feasible to promote, hopefully, private capital or P3 enterprises or something like that to get it treated. And of course, there's a whole host of issues and what it takes to treat and dispose of brine and everything else the bigger committees addressing. But as far as looking at these specific areas and thinking what would it take to make this water available, just looking down your list, Yuma, Winslow, Gila Bend, Wilcox, Pocahontas in the AMA, then Yuma again, all that water has to move if it's going to be of high enough value to make somebody go to the effort of building these large capital intensive industrial facilities. So I don't know if that is counter to what Goodyear thinks is a long-term tie-in or not, but it seemed to me that one of your big goals is to try and preserve the groundwater under your feet, as Bill Chase used to say, for development in your own city.
We have a very limited amount of groundwater under our feet, and so, you know, it's not the long-term plan for the city to use that groundwater for our 100-year supply. I'm sure everyone's aware we're in the process of building a surface water treatment plant in order to take our CAP water. We have a project in our capital improvement plan for 2022 to do a 6 MGD DPR pilot project. So we don't want to be groundwater dependent, but we also don't want to lose the ability to use it if we need to. If somebody decides to drive a truck in the CAP canal and we can't get water for a period of time, or the Buckeye Irrigation District, which has happened just lately, right? You know, we need to be able to use it as an emergency resource, but that's not our plan, to use it as our only supply and then just pay CADRD to replenish it for us. So, but we don't want to see it go away. And I feel like any large withdrawals in the waterlogged area is going to impact us. Anything over and above what's currently being used, and I'm sure the town of Buckeye will eventually use more water, but status quo works for us right now.
But I think, Mike, you made a good point about transportation and moving that water. I mean, that water is going to have to move, and there are a number. I mentioned this at the beginning, that there are a number of statutes and regulatory issues with transportation of this water. And going through the statutes, they're kind of all over the place with different basins and where you're at and how you're moving it around. So I think one of the things that I want to do for this committee is, when we do put together this list, the transportation section, we can kind of try and summarize all of that, so you have a little bit, so everybody has a little bit better idea about what it means to move water from different places. You know, moving water from AMA to AMA has a different meaning in the statutes than moving it from Yuma into an AMA, or moving it from outside the AMA to another area outside the AMA, or statutes say you can't move it from Pinal AMA to anywhere else. So it's all over the place. And so I think one of the things that we should do in this group, as part of this identification of issues, is identifying the transportation issue and the reason that they're there, and the intent, but also that just clarifying it for everybody, because it's not understood very well by everyone all the time, and what nuances there are. So I appreciate that point, bringing that up, so we can kind of look at that, you know what, there may be solutions for this water if it's economically feasible for all parties, but that water still has to move, and what are the hurdles in place for moving that water where it may need to go. So I made a note of that, so I would like to identify that. And so, and I also appreciate you coming in and talking more about some of the other areas that we have highlighted in this chart. I know originally when Bob and the Desal committee went through it, they had a lot of areas that they were looking at, and they narrowed it down to only a few areas, and then they even refined that list even more and narrowed it down to just a few areas, and those few areas were the Yuma area and the West Valley, West Phoenix AMA area. And so we're focusing on all of those, but there are other areas that we're talking about. It's just a matter of what kind of issues come up with those. And the areas that aren't inside the AMAs, I think the transportation issue is the one that's going to be the biggest thing for us as far as regulatory hurdles go in those areas. But talking about what's affected in the AMA, I think is going to be the most beneficial for us to continue to talk about. But with that said, we've had a lot of good conversations about the Buckeye area, and we've kind of pulled in some of the other areas a little bit more. But I kind of wanted to open it up a little bit more to anybody else who might have anything that they were wanting to address today. I mean, we could sit here and chat about a lot of things until 4 o'clock. It's almost 3, and it's Friday, and whoever made this meeting for Friday at 2 o'clock, I don't know. But I don't want to sit here and just, hash over the same thing over and over again. I think the discussion that we've had so far has been very helpful, and it's important for that discussion to have been made. And so I just want to open up to anybody else here on the phone if there's anything, other points that you wanted to make or any other ideas for that. And once we go through those, I'll kind of try and wrap us up and see what we need to do from here. So with that, is there anybody around the table that has a mic that wants to say anything at all and bring up any other ideas? If not, anybody out there in the vast audience that we've got want to say anything? Ken, you're laughing. You want to say anything? Come on, you got to say something, Ken.
Can you hear me?
Ken Seychelles with the CAP. I do think it will be helpful to make some distinctions and how what I sort of heard you identify sort of 3 related issues in terms of within the AMAs: physical availability, transportation, and how it qualifies or doesn't for assured water supply purposes, because there are variations of things that are being potentially kind of mixed together. So under current statute, the CAGRD can't use groundwater that's from within the AMAs as a replenishment supply, but to the extent that there was a supply of groundwater from one of the basins that is eligible for transportation, that can be used for replenishment. So there's things where I think it's going to be helpful to maybe be a little bit more careful matching up kind of maybe even some supplies and where they might go and what implications there are in terms of both transportation and physical availability. Certainly that's going to be all 3 of those elements are front and center for within the urbanized AMAs, where obviously a lot of the interest in terms of the supply is, and a whole host of other connected surface water, groundwater issues. But I think that's the main point.
Great. Thanks, Ken. I appreciate it. Anybody else, real quick? Anybody on the phone would like to say anything? We can hear them, or they can hear us.
Hello, this is Ron Whitler with the City of Buckeye. Can you hear me?
Yeah, we can. Ron, go ahead.
Okay, I just wanted to say regarding the Buckeye area, we're having a challenge even right now, not for future growth, due to the poor quality of the groundwater. So that's what we would want. We would be hoping to find some relief, monetary relief for having to treat the water within or outside of the waterlogged area, because for a few miles north of the waterlogged area, the quality is similar, and so if we're going to have to treat that, we would hope not to incur a replenishment obligation. And also it's so close to the waterlogged area, the areas outside of it, that you wouldn't be able to build a recharge facility anyway. So that's our concern, that there be some kind of exemption for either poor quality or for the waterlogging conditions so that we could treat the water and deliver it to the, the residents that are right there. Not, so that's our concern. Thank you.
Okay. Thanks, Ron. Is there
Thank you, Scott.
Anybody else? All right. Well, I guess to wrap things up, kind of what I've kind of put together here in my notes, and what I think I'd like to do is, I kind of said at the beginning of the meeting that I don't think this is going to be a marathon of meetings and taking up a lot of folks' time, but I think what I'd like to do is take all this information that we talked about today, and I can work with DWR on putting together maybe an outline of what we talked about and kind of the highlights and things like that, and brainstorm a little bit more, and maybe bring us back together one more time to go through that to see if there's anything we need to add, anything we got wrong, things to change. And so I have a pretty good idea of what we want to present to the Desal committee in January. I think they get together mid-January for the Desal committee, and I think that'll be our first opportunity to I guess report to them what we've come up with. But I think we've had a good discussion today. We've gotten a lot of ideas and a lot of information out, and so what I'd like to do is go back and put this all together, and maybe bring us back before that January meeting so we could go through it, and then I could go ahead and present it to the Desal committee and find out if they want us to come back and maybe talk about if they want us to look at possible solutions for some of these issues and throw things out and see what sticks. So right now, the charge to me is just a list of those things that are hurdles for the Desal committee as far as a regulatory and legal aspect goes, and I think we've got a good list, but I want to put all that together first. So if there's no objections to that, I think that's kind of what we'll do. I'll work with DWR. We'll get some things together. Maybe we can bring us all back. It's going to get crazy, the holidays and everybody's schedules, and I know everybody's really busy, but maybe we can try and get together at some point before that January meeting to kind of go through what we've discussed here in a summary and kind of go from there. So anybody has any problems with that? Anybody? Oh, absolutely. Go ahead, Mr. Gladden.
W.T. Gladden, I just want to remind you about the Gila River adjudication. In time, that's going to happen. And this district is 2 miles wide, 30 miles long, right along the Gila River. The likelihood of Buckeye being surface water is a very good chance. And you can't give this water away to somebody else and then have that determination made. That you're going to have a problem.
No, I appreciate that comment. I understand. Yeah, that's a great comment and a great point to make. That it's coming. There is a lot of activity going on with the adjudications right now, and with the proximity to the waterlogged area, with some of that, there is going to be a lot to discuss when that does come up. So I do appreciate that and make sure that that's part of our hurdle that we have for this water. Absolutely, I understand. Thank you very much, Mr. Gladden. Yeah, Mike?
I would say one more thing, Mike Pierce, just on a closing note. The irrigation districts everywhere in the state are going to have to be part of the solution here. Still 70+% of the water used in the state of Arizona is agricultural. We know that is not sustainable either. And Noel and I have talked many times that this district that we're here representing today and others, some of whom I represent and many of whom I don't, recognize that they need to be part of the solution. And we're going to approach this with that kind of an attitude that we need to bring our assets as well as our liabilities to the table, so to speak. So we look forward to whatever you can do to summarize all this and support you in your effort.
Great. Thanks, Mike. I appreciate it.
This is Carol Ward with the Department of Water Resources. Mr. Gladden's comment made me think, you know, we do need to consider other things that are out there. And as we're working on these different committees for the council, and also as Natalie and her team are working to finish up the fourth management plans and build the fifth management plans, we have a lot of things under consideration. And we're looking at safe yield and, you know, what that means and how are we going to continue to work towards safe yield and ensure that we have sustainable supplies. So if we're considering incentivizing, you know, additional groundwater use, at the same time we're trying to identify what the hurdles are to reaching safe yield, you can see that there are some competing ideas there, and I think that merits additional discussion.
No, that is a good point. So I appreciate that as well. Let's see if we can do that. All right. Well, I appreciate that. So with the idea that we have taken exactly an hour, I think if nobody else has any other questions or comments, let's have a great weekend, everybody, okay? Thanks.